Welcome, everyone. I'm Ryan Tarrant, President and CEO of the Jackson County Chamber of Commerce. Just to let everyone know, everyone on today's call will receive a link for the full webinar after, as well as a brief memo from our friends at Curtis, and Berlinski regarding ESTA. ESTA and the minimum wage changes have been one of the top issues since the Michigan Supreme Court ruling last summer that made changes to how we're all going to be doing business effective February 21st. The Jackson County Chamber of Commerce is a member of an 80-plus business organization coalition that has been working with the State House and Senate to try to make some positive changes to the new laws before their effective date. But despite our efforts, only the State House has actually passed legislation to make improvements to these bills, which that business coalition was actually able to help shape. That House bill includes exemptions for all of our small businesses up to 50 employees. But there has been some movement in the state Senate over the last couple of weeks. Last week, the Senate held hearings and introduced a substitute bill, actually, that would make at least some small changes. They were going to, in their legislation, bump the small business designation, where you had to begin giving 72 hours of leave from 10 to 25 employees. And then also making accommodations for some of those industries with staffing ratios. So thinking of hospitals and a lot in the medical field. But in light of that incredibly sort of narrow path to passing workable legislation between now and the 21st, we're happy to be joined today by Tom Leonard, partner with Plunkett Cooney, and Lisa Brown, Vice President of Client Services at HR Collaborative, which is a fractional HR firm that is part of the Connexus Group. If you have any questions at all during today's webinar, I'd invite you to use the Q&A box on the bottom of your screen. Please ask those there. And now I would like to turn things over to Rachel Buchanan, our Vice President of Marketing and Communications, who will be introducing today's speakers and moderating our Q&A after the presentations. Rachel?
Wonderful. Thank you, Ryan. Our first speaker is Tom Leonard, former Speaker of the Michigan House of Representatives. Tom Leonard is a partner in Plunkett Cooney's Lansing office, where he serves as the firm's government relations, public policy, and regulatory practice group leader. He's also a member of the election law practice group. Mr. Leonard served 3 terms in the Michigan House of Representatives between 2013 and 2018. In his third and final term, his colleagues unanimously selected him to serve as the state's 75th House Speaker. In addition, Mr. Leonard reformed Michigan's teacher pension fund, updated Kevin's Law, and rewrote the state's preliminary exam law. Prior to running for public office, Mr. Leonard served as an assistant attorney general for the state of Michigan and as a prosecutor in Genesee County, where he was assigned to the Special Crimes Division. Mr. Leonard graduated from Michigan State University College of Law in 2007 and earned his undergraduate degree from the University of Michigan in 2004. So we welcome Tom Leonard.
Well, thank you, Rachel, for having me, and I can definitely hear the broadcasting and radio voice. So thank you very much for the kind introduction, and Ryan, thank you for the invite and for everybody that's on here. A couple things I want to start out by saying, and I told Ryan this. I am not the firm's Plunkett Cooney's labor and employment attorney, so I probably know about 90% of where we need to go today. And if you ask a question that I don't have the answer to, I'm simply going to just tell you I don't know, and I can get back to you. But I do think I offer a very unique perspective because, as Rachel mentioned, I not only served as the House Speaker, but I served as the House Speaker when we were initially dealing with this entire situation, and we implemented what we thought was going to be a fix for our employers and our employees across the state. Now, before I get into what I have to say, if there's 2 things that I want you to remember and I want you to take away from anything that I'm going to say today, if there's only 2 things that you remember, number 1 is this: please, over the next 10 or 11 days, I implore you, get on the phone, get on the website, and contact your legislator and have your friends do the same. Because I can think of nothing more important and more pressing for our legislature to take up and to fix right now than this. And then the second thing that I would say is, in the event that they don't come to a compromise and this is not fixed over the next 10 to 11 days, make certain that you have somebody like Lisa, make certain you have an attorney, make certain you have somebody that really knows all the ins and outs of this new law so that you can properly implement it with your local or with your small business, because I'm telling you, if not, it could potentially be an absolute disaster and mess for you. So how did we get here? Michigan has in our Constitution what's called the ability to have what's called a citizens initiated law. And what that means is if for some reason the citizens themselves want to have a law implemented, maybe because the governor may have veto power over something and they want to bypass the governor, they can go out and they can collect signatures, and they essentially have to collect 8% of the last election's vote. So back in 2018, what happened was, and very straightforward and bluntly here, some outside special interests from DC spent millions of dollars paying people to collect signatures in 2018, and they collected about 400,000. It went to the Secretary of State's office and was approved, and that's what this Earned Sick Time Act was, in addition to the minimum wage. Now, once those signatures are approved, what happens at that point is the language goes to the legislature, the House and the Senate, and they cannot change anything. They have to give it an up-down vote as is. And the governor has no right to veto. The governor doesn't sign it. It goes straight to the legislature. If the legislature does not act, and I believe it's 40, they've got 40 legislative days to act. If they don't act, it then goes to a vote of the people. And if the people by a majority vote, if they choose to pass this law, it then becomes law. The catch is, and what we were dealing with in 2018 when this came to us and it was put on our laps, is if the legislature votes, if they give it an up-down vote and they adopt it, the legislature then controls or has the ability to amend the law or change it going forward. If the citizens pass it, it then takes a supermajority, a 3/4 vote by both the House and the Senate to actually bring any changes to the law. So when it was sent to us in 2018, we felt that the people's representatives, the legislature, the people that were the legislators that were elected by the people to represent them, were best equipped to make these decisions. So what we did was, in September of 2018, we gave the Earned Sick Time Act language that was sent to us a straight up-down vote, and we passed it. And then a few weeks later, in December of 2018, we came back and we amended it to make it much more palatable for our businesses, our employers, and our employees. And after we did that, a lawsuit was brought, and it took 5 or 6 years to work its way through the state Supreme Court. And just about 6 or 7 months ago, the Supreme Court came back, and it was a 4-3 decision. I still don't know how they came up with this decision, but essentially what they said was, we are going to deem that it was unconstitutional because the legislature acted during the same legislative term. If they would have adopted the legislation and let it go into the next term, and then the next legislature fixed it, that would have been okay. But because they adopted it and changed it in the same legislative term, we are going to rule what they did was unconstitutional. And that's why we are here today. And that's why the legislature needs to act. So I'm going to give a very, very high level. What are some of the things that are scary about this legislation or about the citizens initiated law if the legislature doesn't act and doesn't fix it? As Ryan said, for every 30 hours, you as a business owner are going to be required to give 1 hour of paid sick leave. The only differentiation that the law makes is a small business, which is 9 or less, and then 10 or less is considered essentially a large business, if you will. The smaller businesses, 1 to 9 employees, the employer will be required to give up to 40 paid sick leave hours every year, and then 32 unpaid. If you have 10 or more employees, then you are required to give 72 hours. Now, this law will be a bookkeeping nightmare. You will be required to keep logs and keep all this information to up to 3 years, and you have to keep the sick time. The employee will accumulate the sick time based on essentially the lowest fraction that you keep their hourly time. So for instance, if you keep their time by the hour, then you accumulate the sick time by the hour. But if it's every 6 minutes, if it's every 1/10, you've got to figure out a way for every 1/10 of an hour that they work to figure out what that sick time is going to be. There is a presumption that your books and your log keeping and all of that is going to be accurate. And if it's not, if the state comes in, you could be held liable for not keeping accurate records. The scariest part, I believe, of this law is the litigation that it can open employers up to. So if an employee decides to take sick leave and I will paid sick leave, and I will also say this: there's essentially no requirement. If they can, they are required to give you up to 7 days. But if they can't, the law reads as soon as practicable. And essentially that means they've got to give you no notice. They don't have to find a replacement employee. But what gets really scary is if they take that sick day, going forward, if at any point they are punished for any reason, so let's say they're not doing their job appropriately, let's say they're leaving early, a whole host of things. If they bring a cause of action, there is a presumption that you as the employer retaliated against the employee. And in court, if you cannot prove that the reason that you took any action against them was not the result of them taking a day off or getting sick leave, you are required, I believe, to pay them twice the amount of their time off and liquidated damages. They are entitled to their attorney fees. So this is going to be an absolute litigation nightmare for employers if the legislature doesn't step up and fix this. So with that, I'm going to stop there, and there's a whole host of questions that I could answer, but I want to make certain to answer what's ever on your mind, and I'll turn it over to who's next.
Thank you so much, Tom. You can see as you listen and watch how complicated this is. So we're starting to see some questions flow into the Q&A box along the bottom of your screen. Make sure that you ask those as you think about them, and we will have that session as soon as our next speaker has completed. So the Q&A box, just type your question right in there. We're watching. Next up, we have Lisa Brown. Lisa is a certified HR professional and Vice President of Client Services at HR Collaborative. Her career includes roles with a small family-owned manufacturer and a large big box retailer. Ms. Brown is an avid supporter of community organizations including Girl Scouts of America, Girls on the Run, OutPro, Feeding America, and the John Ball Zoo, and serves as a member of the GVSU Economics Advisory Board. She enjoys engaging with causes that build confidence in young women, promoting a welcoming culture for LGBTQIA plus individuals and allies, and promotes animal welfare and human rights. Her collaborative approach, combined with expertise and empathy, make her an invaluable partner in HR Collaborative's mission to make work better for everyone. And we're excited to hear from Lisa. I'll turn it over to you.
Thank you so much, Rachel. Well, while I get my slides up and going, I want to thank all of you for taking the time out. We know that there's been a lot of movement related to ESTA and the Improved Workforce Act in these past couple of weeks, and nothing like timing, right before we have to implement it next week. So thank you all for joining us today. With that, Tom shared quite a bit about what ESTA is, how we got here, what it means for employers, and it's really great to have that context and know what we're getting into. But there's also more we need to take into consideration or keep in mind about what's going to be impacted at your organization as a result of ESTA being implemented, whether it's in its current state or its modified state due to the House and Senate recommendations. So first, I wanted to share with you a little bit about the impact on policies. We're working with a lot of our clients to help them understand that it's not just their PTO policy that's going to be impacted by this. As Tom had mentioned, their disciplinary policies, attendance policies, accountability policies can all be can be impacted as well. What we've boiled down to is there's really three primary approaches to designing a paid time off program that's compliant with ESTA guidelines as they are today. So Organizations can simply add ESTA as an additional accrual category and maintain their current PTO volume. However, you can have two separate buckets with two separate administrative guidelines, administrative processes around them. As long as your ESTA policy is compliant with the provisions of the Act, you'll be fine. What organizations could also do is separate ESTA from their current PTO. So you'd still have the two separate buckets, but perhaps you reduce your current PTO volume by, up to 72 hours or, by a certain amount to supplement or to offset the impact of now accruing sick time and paid time off or personal time in its own bucket. The third option that we see employers considering or implementing is to maintain their current PTO policy, but update all the provisions to meet the requirements of the Earned Sick Time Act. Now, I have several clients who are like, oh, we have, our current plan is more robust. It offers more time off than ESTA requires. And so we're just going to go ahead and say that our current plan complies with ESTA. Great, you can do that, but you also need to look at the other provisions of your paid time off policy. Going back to what Tom had mentioned, is there's no approval process required for ESTA. It's soon as reasonably possible. So in theory, your PTO, that bucket of PTO, if you're going to switch, if you're going to create, or if you're going to leave it as is and have it just state that it's compliant with ESTA, in theory, your employees never have to give you notice. They don't have to get approval to take PTO. They just have to give you notice. That can be a scheduling or a coverage nightmare for organizations that are heavily reliant on people, maybe in person, on site, on production lines. Some of the other potentials are that unlimited accrual and carryover. If they don't use it, it continues to, accrue. You can cap usage per year at no less than 72 hours. But pretty soon, in a couple of years, you're going to have folks with potentially over, 100, 150 hours accrued, and limiting their usage. Feels like there's a benefit that's available to them that they're not, or that's accrued that's not available to them. The other part is if you have any part of your plan that currently offers a payout with that unlimited accrual and carryover, you're going to want to look at whether or not continuing to have that PTO payout provision is still a wise choice, and that it's financially affordable for your organization to offer that if you're going to, again, roll that ESTA into your current PTO policy. Another policy to take a look at would be your attendance and timekeeping. So as Tom had mentioned, you cannot discipline or take adverse action against employees that have attendance issued due to an ESTA qualifying event. Most of the ESTA qualifying events, you can't request medical documentation unless they've missed 3 consecutive days of work. And some of those reasons may not require a visit to a physician that would warrant a doctor's note or any sort of written explanation. If that is part of your policy now, please be aware that the way the Act is written today is that the company may be responsible for any expense that's incurred by those employees that requires them to get medical documentation. If they were sick, they had a fever, they may not have typically gone to the doctor, but if you're requiring them to provide medical documentation, you could be responsible for that copay, for any medication, any cost incurred for the physician to fill out a absence from work form. So just keeping that in mind. You also must allow usage and track ESTA time in the smallest increment that your timekeeping system allows. So if you currently track employee time down to the minute, you have to allow employees to take their ESTA time in 1-minute increments as well. Like Tom had mentioned, this is going to be an administrative nightmare for most employers who thought streamlining, their timekeeping by using an automated system that tracks down to the minute or real time, it may work against them in the way that the law is written today. Other things to consider is if your organization offers any leaves of absence, whether they're paid or unpaid, and then other benefits available to employees that ESTA may run concurrent with. For example, it can run concurrent or at the same time as any unpaid time off leaves, short-term disability, FMLA. If there's no pay benefit of it, but it's just covered time off, you can have that run concurrently where they can get paid for that time off, but it will still reduce that available time. Some of your other policies, you're going to want to run it sequentially where they're required to use ESTA, and then they can use PTO, or if it's parental leave, whether it's for their child, if they birth a child or a new child in their family, that would qualify for potentially your parental leave program and ESTA. So you're going to have to think about the coordination of benefits with the implementation of ESTA. How to communicate. So if you haven't started communicating what your organization is doing about this, about this plan, about this act, we really should do so now. And you should be informing all of your employees, because this, as the way that the act is written right now, all employees are included. Any W-2 employee, whether they're seasonal, part-time, full-time, salaried, or hourly, all of them are covered. The exception right now the act does exclude independent contractors at this time. There has been clarification on that. And I know that the House bill is proposing that there be more clarification on potentially excluding some other classifications of employee. So if you haven't started communicating yet, do so now. It's really important to do so. You instill confidence in your employees that your plan and your approach to being compliant with ESTA is well thought out, it's compliant, and it's aligned with your organization's values. Some ways that we're advising our clients to do this is to have some formal communication, either at a broader staff meeting, during manager and employee one-on-one, sending out a company-wide memo saying, hey, this is coming and this is how we've prepared for it. There can also be informal communication by sending out like a blanket company email. Of course, posting the required poster that you see on the slide right now, and letting employees know where they can find it, and then preparing some frequently asked questions. You want to make sure that you're also educating your supervisors and managers on what their role in compliance is. We want to make sure that we provide them with any copies of policies that we've made updates to, and any guidance on the administrative procedures, so they know how to handle a request for ESTA, or what they can and can't ask of an employee. Again, we want to work with our supervisors and managers now to instill confidence in them, to feel like they can manage those conversations with their employees and administer the policies according to our practices. And again, this can be provided in formal training sessions, providing them information materials, referring to required postings, and then of course providing them support through emails, reviewing it at team meetings, and providing them with FAQs. Lastly, if you are leveraging technology to manage your ESTA or administer your ESTA policy, which again helps alleviate some of that administrative burden, you're going to want to identify the necessary system changes. If we're going to 2 buckets, can our system accommodate and accrue two buckets at 2 different rates of accrual? Work with your IT or HRIS vendor to implement updates. You should have client support available to you through your vendor to help make the changes. They may not be able to go in and build it for you, but you should be able to lean on them to help you and your team build the programs and accruals that are required for your organization. Of course, we're getting close here, but if you have if you can get in there and get those changes made, make sure you test those changes. Maybe put in some test employees and test their accrual by running some, hourly payrolls to see if it's accruing correctly. Nothing like an employee seeing that they get like 100 and, maybe 72 hours in that first payroll that they want to start to use that we then have to retract from them. Of course, establish some monitoring mechanisms. So we're maybe doing an audit once a month to say, hey, these numbers look right, or hey, let's pick a handful of folks every month and make sure that those accruals look aligned. And then, of course, regularly review compliance changes and address issues. As Tom shared, there's a lot of conversation going back and forth between the House and the Senate, and we're not sure where things are going to land just yet. And they're likely to change quite a bit after this is implemented and more proposed changes, and businesses reach out with their feedback on how it's impacting their organization. There's likely to be some changes made or modifications that hopefully will make it easier on all of us. Little bit about HR Collaborative. Rachel, thank you so much for sharing. But, we are a small organization based in West Michigan, but our goal is to help businesses grow their most valuable asset, which is their people. We also are part of that larger Connexus group, as you had mentioned. And one of the great parts of being part of a large organization, a family of nonprofits, is that as a for-profit ourselves, we can contribute to the broader mission, which is an organization that is committed to inspiring positive economic change, one person, one business, and one community at a time. We have a great family of organizations to help us do that. And for any of you that don't have, are feeling pretty confident about ESTA, or whether you are or not, we do offer free HR health assessments. So following this webinar here, you'll also get access to this QR code and these slides, where if you'd like to talk to us to get a gauge on your HR health, we're happy to talk to you about that. Most of us have had a lot of conversations about ESTA, so we can talk about other things as well if you're in need of or interested in doing so. So with that, Rachel, I'll pass it back over to you.
Excellent. Thank you so much. Definitely some experts here. The Q&A box is open and we do have some questions flowing in. So this is some great conversation today. You were just talking about the timeliness of everything. First question is, with only 11 days before the law takes effect, is there any chance that changes will be made in Lansing before February 21st?
It says Tom right over it.
Let me take that one. No, that's all good. Listen, I am hopeful, but I think it is going to be very difficult. And I hope that the legislature proves me wrong. And I think there's a couple reasons. I mean, number one, you've got the House and the Senate. They are very far apart right now in terms of what they think a compromise should look like. The House's most recent version essentially goes back to a lot of what we had done in 2018, namely making certain that that there's that 50 employee definition. So essentially anybody under under that 50 employee count, this wouldn't apply to. But the second thing, and again, just being very blunt about this, the politics in Lansing are not real good right now. There are a couple other factors out there. The Senate Majority Leader in the Senate that is controlled by Democrats just sued the Republican House Speaker over 9 bills that were passed and left in the House from the previous speaker that was never transmitted to the governor. And now she's suing the current speaker to try to force him to send those bills to the governor right now. So all that to say, the fact that you've got the Senate and the House that are supposed to be negotiating on this, and one side is suing the other over something else and they're not even communicating, I think is going to make it very difficult to get something done over the next 10 days. What I think could happen, and this is just me, I don't have any intel on this, but this is what I'm hoping at least they can do over the next week or so, is maybe reasonable minds and adults will come together and say, you know what, we don't have a compromise right now, but we know that we can sit down and come up with one. We just can't do it over the next 10 days. And let's just pass a clean bill that will extend this implementation date for another 6 months. So that gives us time to actually sit down and gives our employers time to prepare. That is something I could see happening, but that's just me shooting from the gut here.
Sounds good. Thank you. For our next question, they said they'll be disclosing the hours of an employee accrues on their pay stubs. How or what is the requirement to disclose those hours?
That's a great question. That is a question I have as well. It's not specified, to my knowledge, in detail as to what needs to be specified or needs to be disclosed on a regular communication, whether it be in an HRIS or on their pay stub. However, as an employer, you're going to have to keep accurate records as to what their accrual balance and usage are. So I would defer back to what your organization's comfort with transparency is. If you're confident that you're compliance, I would think that the organization should have no reservation in sharing the actual accrual and usage of ESTA time and ensuring that it's compliant with the policy that they have written.
Okay, great. Someone asks, if I front load at least 72 hours, do I need to accrue or allow carryover of ESTA?
So I know that the front-loading option of the 72 hours, or a minimum of 72 hours, is included on the House bill. I believe it's also referenced on the Senate bill. Tom can correct me if I'm wrong, but that is a proposed change that both sides seem to see eye to eye on, that would be deemed an appropriate approach. However, the way that the act is written right now, yes, you absolutely can take that approach, but that doesn't eliminate your requirement to keep records for the accrual and usage of that time on the back end. Now, you don't have to present that to employees, but you will want to have record keeping in place on the back end to track that accrual and usage. Your most likely violation of that would be is if you have hourly folks who work a lot of overtime, they could very easily accrue over that 72 hours in that first year of measurement.
And I was just going to say too, and I think with the way the law is written right now, if it goes into effect, honestly, and this will be up to each individual business owner, but I really think it might be counterproductive to actually front load because, again, as Lisa said, you still have to keep track and accrue all those hours. But if the employee leaves and they haven't accrued the full 72, you can get back what wasn't used. But the problem is you've got to be able to prove what they didn't, that they didn't work enough to accrue those. So frankly, I just don't know what the front loading is going to do because it does nothing with the bookkeeping that you still have to have that's going to be required under this act.
Yeah, agreed.
Wonderful. These are good questions. And also a reminder, the Q&A box is open, so you can ask a question as you think of something. And there's a little cue that we're watching as they come up. The next question is someone who works specifically at a staffing agency. It says, we provide employees to companies and those people who for us at the staffing agency. There we go. Typically, if a person no call, no shows, the employees will call the end of the assignment for that person and ask for a replacement. In a situation like this, can we hold them legally liable for violating the law by not having a job for the person returned to if they claim sick time?
Oh, I love these. These are, again, there's no precedent set in the state of Michigan, right? So this is one of those where it's like, well, I could see the potential for both. If it depends, I think the liability is going to rest on who, and here this is not legal advice. I will defer to Tom to clarify where I'm at. But from the HR perspective, I would want to know what the employer or the employee's relationship is with each of those employers. Are they an employee of the staffing agency, or are they in a joint employer relationship where there's that mutual benefit where both the company that they're placed at and the staffing agency have liability to provide that benefit and to monitor. If it is that the employee is an employee of the staffing agency would not be able to, most of their assignments through a staffing agency to a client is contingency based, right? If they don't like the performance, the work's not there, the contract with the client would dictate what that employee notice to the staffing agency of the employee of that employee for that client. The staffing agency, however, would not be able to take adverse action on that employee if they were a sole W-2 employee of the staffing agency, if they missed work due to an ESTA covered reason, because they are then responsible providing that earned sick time to that employee. And specifically in that act says adverse action cannot be taken against that, which means they would have to try to find them another assignment. They couldn't place them on the do not place list. They wouldn't want to separate their employment with them, and they wouldn't want to financially. They wouldn't want to discipline them by not paying them by taking any financial adverse action as well. Tom, what did I miss?
No, and I was going to say, and on that note, I mean, I don't want to really, confuse anybody here, but one thing that hasn't been mentioned is this act, it applies to part-time and seasonal employees as well. They're not just full-time. And then I believe in the FAQ section, in Leo, the state, they've got an FAQ section, but I think they're updating this thing maybe weekly or daily. I believe last I looked at it, it was implied that this would not apply to contract employees. However, I have spoken to attorneys that have said you don't want to be the test case.
Exactly.
Because the language is not clear. So this could even go so far as applying to actual contract employees.
And I have two clarifying comments. I don't know if this changes an answer or allows for additional conversation, but they said two things. The hours that they use disclosure related to that question, and also they are an employee of the staffing agency itself.
Okay, so if they're an employee of the staffing agency would bear the burden of providing that job protected leave. Yep. And then what was the first clarifying point, Rachel?
The hours that they use disclosure. I don't know if that changes the answer or the perspective on it.
The hours that they use disclosure, meaning that they have to notify the staffing agency of their absence?
Possibly.
Okay. Yeah. So they would, I mean, and again, ESTA doesn't require an approval process. It just requires notification. So the employee would have to notify the staffing agency, not just the company in which they were reporting to be considered in compliance with the act. Again, as Tom had mentioned, I wouldn't want to hold them accountable the first time they called the company that they're reporting to report their absence versus the staffing agency, because that could be deemed, in bad taste. To, again, I wouldn't want to be the sample case to defend myself after the first offense.
And I am jumping to a question that came a little bit later, but I don't know if this was covered, but just in case, as we're on the very similar topic. It says, as a temporary staffing agency, we have hundreds of employees who jump from assignment to assignment with different clients. How long are hours accrued if there's a gap in the assignment? And is there a new waiting period if that happens? It's
a great question. So with the act, again, as it is written and as of today, you have to begin accruing time for an employee on day one, when they start working. You can have a 90-day, that's 90 calendar day, not work day, 90 calendar day waiting period for them to be able to use that time. However, you need to continue accruing that. So if they work a shorter assignment, you still have to keep record of that accrual. If they were to stop an assignment, not have a new assignment, be unavailable for work, you have to hold that bank of time for them for 6 months before they're subject to any new waiting period. So if they go 3, 4, 5 months without an assignment, and then 5 months and 28 days they take a new assignment, you must reinstate their accrued and unused ESTA time from their prior assignments. It doesn't matter what clients they were working with or what companies they were working for. If they're a W-2 employee of the staffing agency or of the company, whether they're temporary, seasonal, whatnot, under the way the act is written today, you cannot reset that time or the introductory period until they have had at least 6 months of gap in employment with your organization.
And I think, Rachel, on the policy front, this is what I've been trying to explain. If you want any ammunition when you're talking to these legislators, is on the policy front, these are the types of examples of how I believe this is really going to hurt employees. As Lisa mentioned, what if somebody's down, they're at that 5-month period and the employer's got some work for them to do? Why wouldn't you wait for that gap to occur and not assign them work? Or what if you are an out-of-state employer that has hundreds of employees across the country, but you happen to have 15 or 20 here in Michigan? Why would you not just lay them off and say, we're just not going to operate in Michigan anymore because I can't deal with this? So on the policy front, I think this is really going to hurt not just employers, but it's going to hurt employees as well.
You guys were referring to independent contractors a moment ago. One question is, how do we track hours for a commissioned paid employee?
So typically, if they're paid solely on commission, or they have, even for folks that have like a base salary and then their commission, if there is a salary component, the way the act is written, it states you can assume a 40-hour work week for those individuals. Now, I would caution you that if you know that a salaried employee is actually working 50 hours a week, it's probably in your best interest to accrue at the rate that you recognize they are likely working. If it's solely commission based, you're going to have to do some work to determine what the expected or average hours worked per week are and accrue at that rate. I'm not aware of any other approach aside from assuming a salaried employee's work week or tracking actual hours worked to calculate that accrual. So your option would be to assume the hours per week or to track actual hours worked.
All right. Another segment of employees. What about employees covered by a collective bargaining agreement?
So they're the few that have an exemption to the February 1 effective date. So if employees are covered by a collective bargaining unit, that contract does supersede ESTA at this time. They are exempt from complying with ESTA until they are up for renegotiation. And then the bargaining unit will have the fun of drafting the new contract to be compliant with whatever version of ESTA exists at that time.
And there is an obscure, I just learned this today, there is an obscure federal law that exempts certain engineering employees that work for a railroad company. So if you're an employer that operates a railroad, you might be exempt.
Somebody says, I have an out-of-state employee working from Virginia. Do we apply the ESTA plan with them as well? Or is it only Michigan employees?
It is only Michigan employees that you're required to offer the benefit to. If you have one single employee that you do not want to track a separate PTO sick time policy for, you're welcome to extend them the same benefit. You're just not legally obligated to.
And don't forget about the Q&A box. Questions. We got a few more and a little bit of time still. This next one is, does ESTA plan require rollover of unused sick time?
Yes, it is unlimited carryover of unused sick time. If you're classifying all of the sick time as ESTA compliant sick time, it would include unlimited carryover of all hours accrued and unused.
Someone says, my current PTO program is more generous than ESTA. We have unlimited PTO. Do I need to make any changes?
So the likelihood of your organization being found in compliant of not providing enough time off for the reasons covered under ESTA is highly unlikely. Similar to what we had mentioned about the front loading, is that does not negate your obligation to accrue and document usage of ESTA. So you don't have to make any changes, but you will want to have a tracking mechanism for both the accrual and usage on the back end should you be audited, just for your own protection. We have not heard any exemption for the more generous or unlimited PTO programs as it's written today.
Okay, we're down to just a couple questions. This is your opportunity, guys. We've got some incredible experts here, so the Q&A box is open. In the meantime, our question we have next is, how does ESTA work with other leave benefits?
It depends on those leave benefits. So this is where organizations are going to want to take a close look within the policies of their organization. Again, your PTO policies, the buckets that you design is just one piece. Again, your attendance and time tracking. As far as the disciplinary side, if you have a point system for your attendance or unpaid, that you're suspended after so many unpaid or after so many points accrued, you're going to have to be really careful that you're not counting any of those ESTA covered absences or attendance events towards that. If you have a perfect attendance bonus, like a monthly perfect attendance bonus, you can't count any of their ESTA absences towards violation of that. They would still have to be included in that attendance incentive. Other unpaid benefits, if you're offering ESTA, they can run concurrent with, which means the same time as. So if you're an organization with more than 50 employees and you provide FMLA, family medical leave, that's 12 weeks of unpaid time off. You can allow the employee to use their ESTA, their earned sick time, to cover portions of that so they receive compensation for the time that they're off while still counting those absences against their family medical leave bucket of time. Again, you're going to want to look at it based, each organization is going to want to look at their policies are written and determine whether or not they can or should have ESTA run concurrent or sequentially with those benefits. What else am I forgetting, Tom? I feel like there's got to be.
I was going to say, Rachel, and it should, I don't know if this, to piggyback off of that too, this does not, ESTA, one thing it does not impact, I believe, or my understanding is vacation time. Okay. So for instance, I've spoken to a lot of employers. For instance, they might give 40 and 40. So 40 hours of sick leave and 40 hours of vacation time. A lot of them are just saying, hey, I'm going to rewrite my policy to just give, 80 of sick time, and I'm taking away the vacation. I don't know what else to do. So this does not impact. There is no requirement that if you currently offer some type of vacation time that you have to remain or have to continue doing that once this goes into effect.
Right. One thing we've also, organizations, ESTA's written that you must have this much time set aside to be used for the purposes defined by ESTA. It doesn't state that you can't be more generous and allow them to use it for other purposes. So in theory, if you went to the one bucket and you said that this time is available for you to use for ESTA qualified reasons or whatever else you deem necessary, you're just going to want to make sure that you're not asking for documentation or there's no approval process required as part of that, because that would be non-compliant with the guidelines of ESTA. A lot of employers, I said, if you're comfortable going with the honor system, that if you tell me you're taking time off for whatever reason, I'm not going to ask you for documentation and we're going to approve it. Just use your best judgment. Then you can do that. It's just ESTA requires that you allow the time, absolutely must be allowed to be used for the defined reasons, but you could absolutely be more generous than the Act requires.
All right, the questions are coming in like crazy now.
There you go.
Got some good points here. Says, do you have to pay out unused ESTA time if an employee leaves your employment?
Only if your policy says you do so. You are not required to. So if your policy currently states that and you're folding ESTA time and accrual into that, I would strongly advise that you either remove that or you limit a maximum payout of that time.
All right. So employees still have to call in and claim ESTA, or can they just not show up and tell us later? And do I have to give ESTA credit retroactively?
It's a loaded question. So, correct, they don't have to call in ahead of time. So as soon as reasonably practicable. So if they're in the emergency room with themselves or their child, calling into work is probably not the first thing on their mind. So if they call you later that day, even the next day to say, hey, I've been in the hospital with my child, that's reasonably practicable. Now, if they come back to work and oh yeah, 2 weeks ago I had that day off and that's ESTA, that was for an ESTA qualified reason, you could probably challenge them a bit on it. But again, I would still want to track that absence against their ESTA time if at all they claim that. Again, as Tom advised, I wouldn't want to be the test case to challenge an employee on the usage of ESTA and just to find out if I'm going to be right or not. I don't want to be the one setting precedent here. However, on the flip side, you can't force your employees to use ESTA. So if they call in and say, oh yeah, I had strep throat for 2 days, you can't say, okay, I'm charging you ESTA. If they decline to use their ESTA time for those absences, you can then hold them accountable to your attendance or call-in policy. Because if they're saying, no, my absence was not due to an ESTA reason, I don't want to use ESTA, then that time could be held to your regular and customary administrative practices.
And going back to that first point and the pushback, if you so choose to do that, again, as mentioned earlier, if there's any type of deemed retaliatory act, the presumption is going to be against you, the employer. And I hate to be so cynical here, but I can just see if this thing goes into effect by the middle of this summer, you're going to see the trial attorney billboards on 127 and on 94 and on 96. It's going to happen because they're going to be entitled to attorney fees, and I think every employer is going to have to ask that question, and the employees are going to catch on to this very quickly. The employer's got to ask, if you're paying them $25, $30 an hour, you've got to ask yourself, is it worth the pushback in getting myself, into some type of lawsuit where the presumption is on me, to prove that my action wasn't retaliatory. And if I lose that, not only do I got to give them their damages, but I also got to pay their attorney fees.
Someone asked, can we require them to fill out a form to use or utilize their ESTA time?
As long as if you're doing it for documentation purposes, that's their request. You can request that. I would love to hear Tom's perspective on it. I don't know if you can require that if they were to notify you, but they can notify you in writing, say an email, a text message, however you customarily receive notice of absences, either during the fact, after the fact, before the fact. Again, you'd want to show more than one attempt at collecting that notification if they did not want to use the process you had in place, just again, to protect you and your organization from, are we being retaliatory?
Yeah, and I don't know anything that would prohibit it. I would note it and I just thought about this, and I'm sorry if Lisa had this in her presentation, I may have missed it, but if you, as the employer, if you require or ask for medical documentation, the law does require you to pay for that documentation if there is a charge for it as well.
Yeah. I would also caution that your form only include what is necessary to be provided by the employee and not anything further, because you could very easily get in that slippery slope of, they're asking personal information. It's basically name, date of absence, hours missed. Was this, is this ESTA covered reason? Yes or no? That's pretty much all you could ask for that notification form.
Great. So earlier we were talking a little bit about bonuses and the special perks. Someone asked if an employee is awarded a $50 bonus for working every hour of their shift during a pay period. If they use ESTA time, could you not hold them accountable for being at work every hour of their pay period?
That is one challenge, is that if they are absent for an ESTA qualifying reason, I would be very hesitant to disadvantage them from an incentive if their only absence was due to an ESTA covered reason. Again, we don't have precedent on that yet, but again, the cost of you giving them that $50 gift card is a lot less than attorney's fees, et cetera. It could get very costly. It wouldn't be worth the contesting of the incentive.
Yeah, I would definitely say if I was counseling somebody, pay the $50.
It's a lot cheaper than your
there's
attorney's
case
time.
law, pay the $50. Yep.
Agreed.
Excellent. We are getting very close to time, but Q&A is still open. If you want to put a question there, I have one more on the lineup right now. Can I have more than one PTO program based on employee classification?
Yes, you can. Most organizations will do different PTO accrual policies for salaried or exempt employees versus non-exempt employees. The only caution I would give to employers is to make sure that when you're developing these time off policies, that you're very clear that it is based on classification or department or position, and it has nothing to do with any personal characteristics or individuals. You can't say, hey, my high performers get more time off than my low performers. You can't have those types of plans. It has to be based on an objective criteria for the job or department, something that would be defined in a handbook or a job description, clarifying who would be eligible and who would not be. Cautions for that, Tom. I know it's not black and white. It's not as easy as it seems. Yes, you can, but you're going to still want to make sure you're not disadvantaging any one group over another.
Well, excellent. We have made it through 19 questions in this hour of time. Do either of you have anything else to share before we turn it over to Ryan and close for our day?
No, I just personally want to emphasize what I said to start. Please take the time to get on the phone, get online, and contact your legislator and implore them to fix this, because I can think of nothing more pressing and nothing more important for them to work on right now. I mean, frankly, the governor and every legislative leader should not be leaving this town and should not be leaving the room until something is hashed out and this is fixed over the next 10 days.
Yeah, I second that from Tom. Both for employers and employees alike. There's just too much gray area for anyone to really go confidently into their PTO programs and the other ancillary programs next week. I don't think enough has been flushed out. But if you're if you're kind of behind the eight ball here, please don't hesitate to reach out to, if you have outsourced HR already, if you have, attorneys or HR professionals in your network, reach out to them. If you don't and you need one, please reach out to HR Collaborative. We give free 30-minute consults and can hopefully walk you through where you're stuck, making sure you go into next Friday as confident as we reasonably can, given the current state of the act.
Excellent. Thank you. I will turn it back over to our president and CEO of the Chamber, Ryan Tarrant.
Thank you, Rachel. And thanks to Lisa and Tom for being with us today. I've been giving presentations on ESTA for a couple of months, and I think every time I give it or I hear about it, I learn something new, because there's so much buried in this that we've all kind of got to get accustomed to between now and next week. So, but just to kind of circle back to what Tom said, I think the biggest thing we can all do right now, in addition to preparing our businesses and our organizations for the implementation of this on the 21st, is really to call legislators. I mean, and for us here in Jackson County, that's State Senator Sue Schenck and State Senator Jonathan Lindsay. They are our two state senators. The House has already passed something, so calling them, encouraging them to take action on this and to make sure that something happens as quickly as possible for our businesses and for our employees. For everyone here, want to thank you for joining us today. Thank you again to Lisa and Tom, and everybody take care.